Good afternoon. I'm George Garvey, the Associate Dean, and I'm here to welcome you on behalf of the Dean, who is in Wilmington, Delaware, doing Dean's work. All right, and is sorry she couldn't be here. She, like I, have given this particular lecture. It really is an extraordinary event in the life of the law school, and it was an honor for me when I did it. The commemorative, I keep calling it a vase. It's not a vase, but that I received has an honored place in my office, and this continues the tradition now with an honored and respected member of this faculty who'll give the talk today. So I said, I'm just here to welcome you. Thank you for being here. I know it will be with Professor Rienzi. It's going to be very interesting and thoughtful, and I know you will find it rewarding. Let me now turn the podium over to Mr. Lipari, and if you would take over and introduce our speaker, I'd appreciate it. Thank you.
Thank you, Dean Garvey. In his motu proprio proclaiming St. Thomas More, the patron saint of statesmen and politicians, Blessed Pope John Paul II declared, "The life of St. Thomas More clearly illustrates a fundamental truth of political ethics. The defense of the Church's freedom from unwarranted interference by the state is at the same time a defense in the name of the primacy of conscience of the individual's freedom vis-a-vis political power." Here we find the basic principle of every civil order consonant with human nature. The preservation of this fundamental right of conscience is at the very heart of Professor Rienzi's work as an academic and lawyer. After graduating from Harvard Law School, where he served as an editor of the Law Review, Professor Rienzi clerked for the Honorable Stephen Williams at the United States Court of Appeals for the District of Columbia. Professor Rienzi then joined the firm of Wilmer Hale. While at the firm, Professor Rienzi began his work litigating First Amendment cases pro bono. Professor Rienzi defended the First Amendment rights of a variety of pro-life individuals and organizations confronted with state limitations on their freedom. Now, as a professor here at the Columbus School of Law, Professor Rienzi works with the Becket Fund to preserve religious liberty. In that capacity, Professor Rienzi has successfully represented Catholic pharmacists in Illinois who are faced with the choice to dispense drugs to which they objected on moral and religious grounds or closed down. He has challenged an abortion clinic buffer zone law in Massachusetts and represents pro-life pregnancy centers faced with onerous regulations aimed at burdening their speech. Presently, Professor Rienzi is representing several religiously affiliated universities and a television network in their challenge to Health and Human Services mandate requiring all insurance plans to cover, with no out-of-pocket expense, contraception, sterilization, and drugs that act as abortifacients. Professor Rienzi has appeared in a wide variety of news media to discuss the religious liberty issues at stake. In all of this work, Professor Rienzi has modeled St. Thomas More as a zealous defender of the right of conscience. The John Paul II Guild of Catholic Lawyers is therefore honored to bestow on Professor Rienzi the Mary Mere of Justice Award, and we are pleased to hear him speak on religious liberty, free speech, and the fight for life.
Thank you very much, and thank you, Austin, for that kind introduction. Thank you very much to the Guild for inviting me here to speak today. Thank you to all of you for coming. It's an honor to be here and to be part of a discussion about pursuing justice through the law. There are many ways to use a law degree to seek justice. Some might do that the way Professors Brieger and Destro have done it, reaching out to people of different faiths and cultures to promote a greater understanding. Some might pursue justice through the law like last year's speaker, Professor Scully, who for many years has been representing the poor, the elderly, and the marginalized in our Columbus Legal Services Clinic, and teaching so many of our students to do the same. Others might pursue justice like Professor Leary, using the law to protect our children from adults who are supposed to care for them, but end up abusing them instead. And others might work toward a more just treatment of convicted criminals, like Professor Drinan does with her work on capital punishment and prison overcrowding. Because even people who have committed terrible crimes are still our brothers and sisters, they are still human beings, and as such, they still deserve to be treated with justice and humanity. At some level, all of this work is about using the law to protect the vulnerable, the powerless, and the voiceless. And it is a wonderful thing about the law that it offers so many different ways to help those who need our help, so many different ways to make our world a better, more loving, and more just place. For me, the best way to use my law degree to promote justice is to help the unborn. I believe the science is overwhelmingly clear that human life starts at conception. I believe the science is equally clear that from that moment there is a new, unique human individual who can never be replaced or repeated. I believe that abortion is the legalized killing of those members of the human family who happen to be small, weak, voiceless, and dependent as they pass through early stages of life through which each of us once passed. And I believe that this killing is legal and tolerated in our system precisely because the victims are small, weak, voiceless, and dependent. To me, the fact that we allow those who have grown large enough to kill those who are too small to defend themselves, the fact that in some quarters we celebrate this and venerate it as an indispensable aspect of human liberty is a great tragedy and a great injustice. Of course, whether I like it or not, that great injustice is currently enshrined in our constitutional system. As we all know, the Supreme Court's decisions in Roe and Casey effectively read the unborn out of the human family, effectively deciding that they are not quite developed, independent, or visible enough for legal protection. In this sense, Roe follows a long tradition of the more powerful groups in our society trying to define the humanity of the less powerful. For example, for hundreds of years, we told ourselves that Native Americans were uncivilized savages, so that we did not need to protect their rights, and their lands and their resources could be taken by more powerful groups who wanted them. We likewise spent hundreds of years falsely claiming that African slaves who came here in chains were of an inferior race, that they were less than fully human, that they were neither suitable for nor desirous of or capable of equal treatment and equal membership in society. We likewise spent much of our history acting as if the mentally ill and the physically handicapped were also subhuman, needing to be locked away or forcibly sterilized by the government even into the 1970s, because the healthier members of society believed them unsuitable for inclusion. Remarkably, the court in Roe said that it didn't even need to figure out whether human beings were alive in the womb in order to read the unborn out of all legal protection. The court said it wouldn't even hazard a guess as to whether human life had started in the womb. But of course, by 1973, we had already known for a very long time that human beings are alive in the womb. Virtually every state had outlawed abortion by the mid-1800s, and there's strong evidence that the practice was illegal at common law for centuries before that. In 1859, the American Medical Association declared abortion to be, quote, the unwarrantable destruction of human life. And even 150 years ago, the AMA said there could be no credible scientific doubts that human beings were alive in the womb. They said any doubts about, quote, the actual and independent existence of the child before birth as a living being must be based and only based upon mistaken and exploded medical dogmas. In fact, even the New York Times once understood this point. In 1871, they wrote in an editorial that abortion resulted in, quote, thousands of human beings murdered before they have seen the light of this world. So these are facts that as a society we have known for a very long time. We knew them for more than a century before Roe. And whatever doubts the justices had in 1973 at the time of Roe are surely insupportable today in our age of 3D and 4D ultrasounds and in utero surgeries. In short, Roe is built on the lie that we're not sure these people are alive. And in truth, there is no scientific doubt that they are alive, and the only real question is the moral and legal one of whether we value these living human beings enough to protect them, to provide them with justice. Of course, millions of Americans hold the opposing view on the question of abortion. They believe that abortion is a fundamental individual liberty right. They believe that a human being in the womb is entitled only to conditional protection, to be protected if the mother wants him or her protected, and discarded if the mother wants him or her discarded. While I disagree with this view, I never doubt the good faith and sincerity of those who hold it. I just think they are mistaken, and I'm quite sure they think I'm mistaken. And in a free country, that's fine. Folks on both sides are obviously entitled to their respective points of view, and obviously entitled to try to convince their fellow citizens that they are right. So even though the court decided as it did in Roe and Casey, as a matter of First Amendment law, there should be no question that those who disagree with the court have basic First Amendment freedoms to speak up in defense of life, to try to convince others to value that life, and to participate in the public square without being forced to support or participate in abortions. These are principles that I think and hope most pro-choice people of good faith can share as well. After all, the mantra of choice would seem pretty hollow if it meant that unwilling people could be forced to participate in someone else's choice to have an abortion and could be not denied their own right to choose whether to support or participate in the practice. Yet there was always a danger that Roe and Casey would somehow lessen the First Amendment freedoms of speech and religion for those who are pro-life. Justice O'Connor once wrote that the court's treatment of abortion, quote, made it painfully clear that no legal rule or doctrine is safe from ad hoc nullification by the court to protect abortion. Justice O'Connor, of course, is one of the signers of the opinion in Casey. For a time, it seemed that the First Amendment would be no exception. The low point in this regard was the court's 2000 decision in Hill v. Colorado, in which the court allowed criminal penalties to be assessed against even peaceful speech on public sidewalks by pro-life speakers. It probably surprised nobody that Justices Scalia and Thomas disliked this decision. After all, they didn't like Roe and Casey either. But Justice Kennedy wrote at the time that the decision contradicted, quote, more than half a century of well-established First Amendment principles, and did so in order to penalize pro-life speech. That's a remarkable assertion from Justice Kennedy, who of course co-authored the joint opinion in Casey. Professor Lawrence Tribe, another well-known supporter of Roe and Casey, was equally critical. He said that the Hill decision was slam-dunk simple and slam-dunk wrong, and most other scholars agreed. That was back in 2000, but I'm happy to report that things have gotten much better for the First Amendment rights of pro-lifers since that low point in 2000. On one hand, there has been a steady effort to burden pro-life speech and to force pro-lifers to choose between violating their beliefs or quitting the public square. But lately, the courts, with a few exceptions, have been doing a very good job of ensuring that the First Amendment freedoms of pro-lifers are not sacrificed at the altar of Roe and Casey. For example, in 2005, Governor Blagojevich issued an administrative rule requiring all pharmacists and pharmacies in the state of Illinois to dispense drugs called emergency contraceptives, which are drugs that can act after conception and kill a small living human embryo. The governor said his rule was designed to make sure religion didn't stand in the way at the pharmacy, and that religious pharmacists should simply find another profession if they didn't like giving out drugs that cause early abortions. The governor's public argument for the rule had several parts. First, he said the pharmacists are just wrong. These emergency contraceptives are no different from regular contraceptives because they act before the embryo can implant in the uterine wall. So he said basically this is just about the pill and regular contraception. The pharmacists are just wrong that they're being asked to kill anyone. Second, he argued that religious objections meant that women were being left unable to get access to emergency contraceptives. and that this access problem was creating a public health problem that amounted to a compelling state interest. Last spring, after 6 years of litigation, we brought that case to trial. And when the evidence was presented, and when the state had to actually put witnesses on the stand to testify under oath, it turned out that the entire basis for the law was a sham. The disclosures from the FDA and from the manufacturer unambiguously state that the emergency contraceptive drugs can act to stop implantation. The state put on a medical expert, a medical school professor from Northwestern with more than 3 decades of practice and teaching experience. And he admitted what every embryology textbook teaches, which is at that point of implantation, what you have already is a new, unique, living human individual at the moment of conception. And he admitted that that was true, and he admitted that that embryo was alive before implantation. So it turned out that Governor Blagojevich's first argument was wrong on the science, even according to his own hand-picked experts. It turned out the pharmacists were quite right that they were being asked to participate in killing a new, unique human individual. The fight wasn't just about the pill after all. Second, both the state's experts and its fact witnesses admitted that there actually was no access problem at all about emergency contraception because the drugs were widely available in lots of different places. In fact, none of them had ever even heard of a single actual person who had been unable to get the drug because of a religious objection. Not a single real person. This really should surprise nobody, because the access argument here was always a fake. Emergency contraceptives are widely available at pharmacies. Most pharmacies are happy to sell them and make money selling them. They're available over the internet. They're available by telephone. The government gives them out for free when the government wants to. One of the pharmacies in the case was located in Chicago. There are dozens of pharmacies within a couple miles of this one. Another was located 3 blocks from a government pharmacy that gives the drug out. So in truth, there was no access problem at all. They couldn't present testimony about anybody who had ever had difficulty getting the drug. Nor had the government ever done anything to make the drug more widely available. They had not posted lists of pharmacies that would sell it. They had not asked doctors who are willing to prescribe it to give it out directly. They hadn't sent people vouchers to help them get it. This claim about an access problem was completely false. So the state of Illinois was willing to close these pharmacies down. They were willing to force these pharmacists out of business, force them out of the only career they'd ever known. And these were people in their early 50s who had spent their whole lives in the profession and aren't exactly in a position to go find a new one. They were willing to force them down, shut down the stores, force the pharmacists out of business, all for a public health problem that turned out not to exist at all when they had to answer questions under oath. Thankfully, the court in that case declared the law a violation of the Free Exercise Clause, something that had been thought to be virtually impossible to do after the Supreme Court's Smith decision. But here the court acknowledged the obvious, that the rule was expressly designed to target religious objectors, that there was no evidence that any religious objections had ever interfered with a single actual person getting the drug, that the government had no compelling interest in driving these people out of the profession, and that it had certainly not pursued its interest in expanding access in the least restrictive means. I wish I could tell you that Illinois was alone in trying to force people out of their professions where there's no real health problem at all, but they're not. Washington State in the mid-2000s did the exact same thing. And last week, a federal court in Washington State entered a very similar ruling to the one that was entered in Illinois, finding that state's effort to force pharmacists to sell these drugs likewise unconstitutional under the First Amendment. The similarities between the cases are astounding. As in Illinois, the evidence was clear that the government had set out to target religious objections. As in Illinois, it was clear that the government would accept a whole range of secular reasons for not selling a drug, but it wouldn't accept religious ones. In Illinois, they said, well, you could have common sense business reasons not to carry a drug. That's okay with us. It's the religious stuff we don't like. As in Illinois, the state of Washington could offer no evidence of a single actual person who was ever unable to get the drug because of a religious objection. Not one. There's a pattern there. And as in Illinois, the government had been willing to shut down these pharmacies and force these pharmacies to leave the only profession they'd ever known in the middle of their careers and lives to solve a claimed public health problem that did not exist. Over the past 3 years, we've seen similar developments in the group of cases concerning government efforts to regulate the speech of pro-life but not pro-choice pregnancy counselors. Pro-life pregnancy centers exist to make sure that women, and particularly poor and disadvantaged women, know that they have real choices other than abortion. They do things like help young women who have been kicked out by their parents or boyfriends find homes, and when necessary, get help and protection from domestic violence. They help women navigate the system so they can get on government aid. They provide parenting classes and maternity clothes and diapers and formula and love and support and anything else they can think of so that a woman does not have an abortion because she thinks she is unloved or unsupported or has no other choice, and so she does not have an abortion simply because she's being pressured or coerced by angry parents or boyfriends. These counselors are on the front lines trying to provide meaningful choices to real people in real difficult situations, and it is an honor and a privilege to represent them and be associated with them. The Pregnancy Center sign laws exist to undermine the pro-life speech and mission of these women. The very first bill tells you everything you need to know about the real motivation behind these laws. The first one was proposed in Maryland a few years ago. That bill would have required every conversation by a pro-life pregnancy counselor to start like this. Before we start talking, I have to tell you, I'm not required to provide you with factually accurate information. You have to start the discussion by saying, I'm not required to tell you the truth. And of course, starting any discussion with, before we start talking, just so you know I'm allowed to lie to you, is the fastest way to undermine the speaker's credibility, right? Try starting your next job interview or blind date with the line, I'm not required to provide you with accurate information. It may be true, but it's a good way to kill your credibility. Even more egregious in that first law was a requirement that every discussion start with a disclaimer that this is not intended to form a doctor-patient relationship. That disclaimer was required even for pro-life doctors. In other words, if you're a doctor who isn't willing to refer for abortion, you have to start your discussions about pregnancy options by saying, this is not intended to be a doctor-patient relationship. In short, if you're pro-life and a doctor, you were required to lie. This is particularly strange, given that if you're a pro-choice counselor with absolutely no medical training whatsoever, you didn't have to give any disclaimer at all. In other words, the fact that at the end you were willing to say, and here's how you get to Planned Parenthood, meant you didn't have to tell anybody about whether you were medical or not. Thankfully, that Maryland law was defeated in the legislature. But the national pro-choice groups liked the idea of targeting these centers, which are in many ways their direct competitors. So they devised a strategy of pursuing these laws in places where they thought they had friendly local legislatures and could get friendly judges. And they succeeded in getting the laws passed in a variety of jurisdictions: Baltimore, Montgomery County, Maryland, New York City, Austin, Texas, San Francisco. And in those places, they imposed a variety of forced statements to be required by pro-life counselors, but not pro-choice ones. But when the cases actually got to discovery and got to court, when the government actually needed to present testimony under oath about the reasons for the laws, these laws, like the pharmacy requirements, turned out to be based on complete fiction. The public argument for these laws was that women were being tricked into thinking that these pro-life centers were really doctors' offices, and therefore they were foregoing needed medical care. Yet when asked under oath, the governments had to admit that they were not aware of a single actual woman who was ever confused about whether one of these centers was medical. Zero. Nor were they able to come forward with any evidence that the pro-lifers were falsely holding themselves out as medical facilities when they were not. Again, this shouldn't really be surprising. In the Baltimore case, for example, the pro-life center is in the basement of St. Bridget's Roman Catholic Church. Is it really plausible that anyone walks into St. Bridget's Roman Catholic Church thinking they're going to get an abortion or an appointment with a gynecologist? It's not true. The claim that these centers were a barrier to real medical care was also baseless. So too was the government's claim that these centers must be holding themselves out as medical simply because they wanted to talk about pregnancy options, as if the question of what to do about a pregnancy is solely the province of people who went to medical school. One Montgomery County legislator candidly admitted, and this is the guy who actually wrote the Montgomery County law, quote, "We are 9 pro-choice Democratic council members in an election year. We have to pass something." And that's really it, right? In other words, the legislature passed the law not because they had evidence of an actual problem. They passed the law because they had a political problem. The issue had been raised, and they needed to move on it. And in the process, they were perfectly willing to target good people who were seeking to provide real choices to pregnant women in trouble, and they were perfectly willing to subject those women to crippling fines and try to make them speak about abortion and pregnancy in ways that the government wanted. As with the pharmacy cases, every single court to consider the issue, including courts in so-called deep blue states like New York and Maryland, with judges appointed by pro-choice Democratic presidents, every one of those courts has found these laws to be subject to strict scrutiny and either entirely or mostly unconstitutional. As with the pharmacist cases, we see a pattern: a false public claim that people who are pro-life need to be silenced or burdened or forced from their profession or the public square because they are harming women and interfering with access to medical care. And when litigated and vigorously challenged in courts, those claims are revealed to be entirely baseless, without a shred of supporting evidence of an actual real-world problem. Nor do the pregnancy center and pharmacy cases stand in isolation. In late 2011, a New Jersey state hospital tried to force all the nurses in its outpatient surgery center to train for abortions, even though many had religious objections. That's a clear violation of federal law. Yet until they were dragged to court, the state was perfectly willing to use the nurses' unwillingness to perform abortions to force them out of their jobs. And the state backed down at the courthouse, but not before. And in the Ninth Circuit last year, that Court of Appeals stated something very obvious: that the government has no authority to prefer speech by people from abortion clinics on the public sidewalks over speech by pro-lifers. Now, that's basic First Amendment law, and it shouldn't be a surprise to see anyone say it. But it was surprising because for the past decade, the First Circuit has said there's nothing at all wrong with the state of Massachusetts saying on certain parts of the public sidewalks, speakers from Planned Parenthood can speak as they wish, and speakers who oppose Planned Parenthood can go to jail for 2.5 years, even for entirely peaceful speech on a public sidewalk because it happens to be near an abortion clinic. The Ninth Circuit's decision may offer the court the chance to revisit its slam-dunk wrong decision from Hill, which likely no longer commands a majority from the court. But like the pharmacy and the pregnancy center cases, these are situations in which the coercive power of the government is being brought to bear to stop people from speaking or living according to their pro-life beliefs, and the courts are rightly rejecting the attempts. The recent public fighting about the HHS contraceptive mandate has all the hallmarks of these cases. The administration argues that the drugs are very popular and that most people, most private employers, already provide them in their insurance plans. But popularity is, of course, irrelevant to constitutional rights. Majority views don't need protection. Minority ones do. And the fact that some Catholics or some Catholic institutions and some other institutions are willing to provide the drugs has no effect on whether other people are entitled to their own religious objections. We don't say that as long as one Quaker is willing to fight in the military, the rest of them lose their exemption, right? And we shouldn't say the same thing here. The government argues that these drugs are just contraceptives and they don't cause abortions. Well, that argument is as wrong here as it was in Illinois and Washington. Last week, I had a minor spat with the New York Times over this argument, and to their credit, they changed their view. Michael Warsaw, who is the CEO of EWTN, the Catholic broadcaster, one of the people challenging this law, had written an op-ed. And in his op-ed, which the New York Times was good enough to run, in his op-ed, he had asserted that these drugs kill living human embryos. And a couple days later, the New York Times wrote to us and said, you know what, we have to change that line about the embryos. There's no proof that these drugs hurt human embryos at all. The good news is it took about 45 seconds on Google for me to find the right documents and email them to the New York Times and say, just look at what the FDA says, and here's the website from the people who make them. They absolutely do that. It's not up for dispute. And the New York Times, to their great credit, said, okay, we won't run the correction we had planned. That's great news. I was thrilled that they were willing to do that they weren't going to distort the truth. But it's shocking to me that the very smart people at the New York Times, right, could be so certain that they're right about what these drugs do that they would be willing to put their name on a correction, to change what somebody else wrote, and to be so wrong about it and so quickly correct it. So I'm thrilled that they changed it. But I think the fact that that was their view and they were going to run the correction until we asked them not to says a whole lot about the amount of misinformation that's out there. Lastly, the government argues that there is an access problem here. But as with the pharmacy cases, there is simply no access problem at all. It's a complete fake. Every time the government talks about this, you will hear them cite the stats that 95 or 98 or 99.9% of people already use the drugs, right? There is no access problem to something that almost everybody uses, according to the government. But if there is an access problem, there's no reason to believe that the only way to solve it is to force religious objectors to give it out. For example, one of the organizations I represent at the Becket Fund is Belmont Abbey College, which is a small Catholic liberal arts school in North Carolina that is run by Benedictine Catholic monks. If there's a problem with access to contraceptives in North Carolina, the federal government knows exactly how to solve it. In fact, there are already today more than 130 federally funded Title X clinics in North Carolina giving out contraceptives to people for free. They give them out to more than 100,000 people in the state. Obviously, if the federal government wants to distribute contraceptives to more people in North Carolina, it knows how to do that. The notion that the only way to get your contraceptives in North Carolina is to have Benedictine monks hand them out is on its face absurd. Yet despite the flimsiness of the government's arguments here, they are forging ahead and trying to create this world in which people who wish to protect the sanctity of life have two choices: either be willing to pay for the drugs that kill human embryos or get out of the public square entirely. And in this regard, the HHS mandate is far worse than the regulations of the medical professions for the pharmacists and the nurses. Those regulations tell people there's one or two or three professions that you can't go into if you want to live by this religious belief. But the HHS regulations are far broader. They tell everyone that they cannot run any business of any kind. You cannot employ someone to work in a law firm, a bakery, a gas station, a widget factory, any place, unless you're willing to pay for these drugs. Now, they shouldn't win that fight. I don't think they'll win that fight. The law is very clear. But the fact that they're trying is a direct assault on the continued participation of pro-life institutions and pro-life individuals in the public square. Let me close by making three short observations that tie these cases together. First, while I have no doubt of the good faith and decency of most people with whom I disagree about abortion, I do think there are some in our society who actually want to make the view that humans are alive in the womb and worthy of protection unacceptable and incompatible with participation in the public square. I think there are some people who realize that if pro-life speech can be burdened and limited, and if they can force people to act contrary to their pro-life beliefs, that over time those beliefs will wear away or be rationalized away and disappear from the public square. When Secretary Sebelius announced to abortion activists, quote, "We are at war," I take her at her word. I don't think these moves are accidental, and I think the pattern is too clear to ignore. Second, while Secretary Sebelius is entitled to declare her war, the very heartening news is that I think she's unlikely to win it. Generally speaking, I think these cases show that the courts have been pretty good lately on the First Amendment rights of people who are pro-life. And the Supreme Court's recent decision in the Hosanna Tabor case, where the court 9-0 rejected the administration's narrow view of religious liberty as extreme and untenable and incompatible with the First Amendment, I think bodes very well for people claiming religious freedom. Third and finally, I want to return to the issue of justice. Whether one agrees with these pro-lifers or not, it should be clear to everybody, to all people of good faith, that these are people who are seeking justice in their own way. They are not racist or sexist or hateful people, but people motivated by love and concern for a class of human beings that our law does not yet embrace. Their view of the group of human beings to whom we owe justice just happens to be a bit broader than the Supreme Court's. These people are trying to make the world a better, kinder, and more just place in which all human life is protected. And they are asking for something very minimal here. They are simply asking for the right not to be forced to be involved in what they view as a grave injustice. These are the kind of people I suggest we should want in our public square. These are people who are so committed to justice, people who are so committed to loving their neighbor, even if that neighbor happens to be small, vulnerable, or handicapped. These are people who are committed to living their lives without harming others. These are the kinds of people we should want in our public square and in our professions, even if you happen to disagree with them on the merits of one particular issue. Martin Luther King famously observed that the moral arc of the universe is long, but it bends toward justice. Reverend King was right, of course, but let me add a caveat. I don't think the arc of the universe bends toward justice on its own. As Reverend King's life demonstrates, the arc of the universe bends toward justice when we have a public square in which people are free to push that arc toward justice with their words and their example. Bending the arc toward justice is, of course, about reaching the right substantive results, and I certainly look forward to the day when we provide justice for even the smallest members of our human family. But we can only get to that substantive result, or any substantive result worthy of the name justice, if we preserve the ability of dissenters to challenge the current prevailing views of justice by their words and by their refusal to participate in injustices. In short, the moral arc of the universe can't bend toward justice if we've cleared the public square of those who would push it that way. And that is why a strong First Amendment protection of speech and individual conscience is essential to any sincere effort to build a just society. Thank you.
It's an honor to present the Mary Mirror of Justice Award to Professor Rienzi. In the tradition of Mary Mirror of Justice lecturers, he has demonstrated the pursuit of peace through justice. His advancements in the areas of religious liberty and pro-life advocacy are remarkable and a reflection of the values and the virtues that we all strive for and that we're challenged to represent. On behalf of the Pope John Paul II Guild of Catholic Lawyers, it's an honor to have this opportunity to recognize your contributions.
It is an honor to have it.
Thank you.
Sure, sure.
If there's any questions, now would be the time to ask them.
Cara?
Okay, so on the HHS mandate, so I've been following it, like all of us, I think, in the newspapers, but I'll admit, I haven't dedicated the time to think through the common law analysis of it. So I'm wondering if you can help me do that. So let's say I am a member of a religion which espouses the belief that after 50, people shouldn't work, right? We revere those over 50 who shouldn't work. But clearly that violates labor law. So why is that? Explain to me, or help me understand how that's not like an employer saying, I don't want to provide birth control.
So you're saying if a person says that it is my religious belief that I need to fire people who are over 50 as opposed to that I can't.
Right. As part of my religious belief, I don't want to employ people over 50. Because I'm thinking through, well, someone who is defending the HHS mandate will say, well, this is just like any other labor law, right? We have labor laws that regulate employers. So why is this distinct?
So I think there are a few reasons. One, I mean, the test, and since we're dealing with the federal government, the test actually, there's the First Amendment is there and Smith is there, but the Religious Freedom Restoration Act from 1993 actually gives us the governing standard, which is if it imposes a substantial burden on the religion, then the government's rule can only survive if it has a compelling interest and if the law is narrowly tailored to serve that interest. I haven't thought through the details of people over 50 in that question, but I would say that the government's argument that it has a compelling interest in making you not refuse to hire old people, black people, women, whatever, is a zillion times stronger than its argument that it has a compelling interest in making people pay for a drug that there are other ways to get. So, off the top of my head, I think the government would have a much better argument that they have a compelling interest in eliminating age discrimination in employment, whereas here, just if you look at what the government says, the idea that there's a compelling need to drag these people in and say, you got to give it, as opposed to the government doing it or giving people vouchers and stuff like that. So one answer is I think the compelling interest and the least restrictive means things are harder. I mean, I guess the other thing is I would say the least restrictive means argument, it's hard to see. I have an easier time seeing on the fire everybody over 50 thing saying, well, the least restrictive means is to say you can't do that, than here saying that the least restrictive way to get people contraceptives is by making religious employers who don't want to do it provide it. Again, given the existence of other ways that we already do that, I think it's different. Yeah.
It seems to me that components of the HHS mandate kind of hit the whole, they frame the whole argument as one of women's rights versus religious rights. And, like you said, they cite the statistics that 90% of Catholics or whoever already use, birth control in some form or another at some point in their life. How do you just counter that with the access issue, that it's not really about access? How do you frame it? So
I think it's obvious that the goal is to make it a women's issue and to make it this is just a fight about contraception, right? I mean, I think to me it's very clear that that is the goal. And the job of people opposing it is to say it's actually about religious liberty. It is the idea that last week before the mandate, women were being denied access to contraceptives is, I think, objectively false and, I think relatively easy to prove. So I think it's a matter of educating people and saying, look, the question is not, I heard somebody on the radio, somebody in an interview said to me, are we really moving toward a world in which there's no access to contraceptives? And in my head, I can't say what I was thinking in my head, but I'll clean it up for you. I was thinking, you must be kidding me, right? It's the most commonly used drug on the planet. Like, there is no question that there's access to it. The idea that there is only access to it if the monks hand it out is loopy. I mean, it's really loopy. And so I think there's a need to just hit back at that and say, no, you're lying. There's not an access problem. Every time you say there's an access problem, you're telling a lie. You may think that people need help paying for it, right? It's possible you think that. Although, again, if you listen to Secretary Sebelius, the truth is insurance companies want to give it out for free all the time, right? So there shouldn't even be the cost problem. But they've said there's a cost problem. If you think there's a cost problem, fine. Send people vouchers or give it out for free or find some other way or get the willing doctors to give it out or work with Planned Parenthood. They want to give it out. Let them give it out, right? The point is, if there's any access problem at all, you got 19 zillion different ways to solve it, and it's a totally unnecessary burden on religion. Put it this way. I think in a context like Quakers who don't want to fight in the Revolution, right? We had a dire situation there. We needed everybody we can get. Washington still didn't make them fight, to his credit. But that's a real tough situation where religion and the demands of the civil government are really sort of bumping up against each other, and it's hard to figure out how you solve that. This one's really, really easy to figure out how you solve it if you want. This is not the kind of situation where, religion needs to get some really good deal and we have to really work out a complicated thing. We give the stuff out to people for free all the time. There's just no need for the conflict, honestly. Yeah?
I had a question about the difference between the religious institutions themselves and people in pews. So if I have a medium-sized business, but obviously in my charter I'm not religiously affiliated, but my personal beliefs would be against contraception, would they have a valid argument as well along the same lines?
They absolutely would, and I do think those cases are coming soon. And that's one of the problems with the president's accommodation, right? The president's accommodation sets up this three-tiered world. Tier one are the churches that do it the way he wants, which is you only talk about religion and you don't hire people and you don't help people of other faiths, right? If you're the president's kind of church, you're in the top tier, you get full religious protection. If you're one of these nonprofit religious-ish institutions in the middle, you get sort of the halfway protection of, well, we won't write it in your policy, but we'll kind of staple it onto the back when you're not looking, right? We'll make the insurer give it out even if it's not written in there. You get sort of the middle, tier two type protection. If you're the kind of person you just described, regular individual American who has religious views and is in business to earn money for his or her family, you have zero protection, according to this president. You don't get a religious exemption right. Now, that's totally contrary to the First Amendment. It's totally contrary to the Religious Freedom Restoration Act. And the idea of the government looking at churches and saying, well, those are good enough. This one, let me see the books. Let me see if you fed too many Jews and atheists in the soup kitchen. The idea the government's going around doing that and picking and choosing is really bizarre and has no place in any of our First Amendment cases. So those people are in for a huge problem, and they get zero protection under any accommodation that anybody's ever talked to, which is why I think you should expect to see them in court very soon. Jessica?
I'm still trying to figure out how to word this in my head. What about the argument about this being kind of a discrimination by the employer against employees, or inferring that employees, by working for religious organizations, kind of surrender to the beliefs of that institution?
I think there are three possible questions in there. And I'll do them quickly in order. One, part of the conflict is because we have this goofy system where everyone's insurance comes from their employer, right? And we have this healthcare law that now requires the employers to provide it or slaps them with gigantic fines. Like Notre Dame, if they decided not to do this, $10 million a year, huge fines. We could separate that whole problem by saying we're going to do insurance just in an open free market as opposed to employer-driven. But the way the tax code is set up, this is just the world we're in. So one is we could separate that problem and have people not have to worry about the religious views of the people they work for easily, right? We should, I mean, it's not easy, but that would be a neat, clean way to do it. As to whether it's discrimination, the EEOC has argued that, but the highest court to look at it has said they're not right and it's not the law. Their argument was always, well, if you pay for Viagra, you got to pay for birth control too, otherwise that's sex discrimination. And if you think about that, that doesn't make a lot of sense, right? Viagra is actually not the male equivalent of a birth control pill. They do different things, right? Both in the same general area, but different stuff. And so it never was sex discrimination to do it. The right comparison would be if somebody said, well, I'll pay for men to have vasectomies, but not for women to have tubal ligations. That would actually sound like sex discrimination to me. But of course, there's nobody who's got that religious view. Nobody was asking to do that. But let me just say this. If the EEOC actually thinks it's sex discrimination to treat those things differently, I'd look forward to them walking down to HHS with the complaint against HHS, because this mandate treats tubal ligations differently from vasectomies, treats the birth control pill differently from Viagra, right? This says if it's a woman we're sterilizing, great, you got to pay for it, it's free. Go ahead. If it's a man we're sterilizing, you're on your own for that. You got to do that yourself. I don't think they really believe that it's sex discrimination. I think that's always been kind of bogus, and I think their actions show that it's not. Yeah.
I think framing the argument, of course, in this debate is the most important step, because once you do that and you put it in terms of sanctity of life rather than an issue of privacy or women's rights, it seems like it would be a pretty easy issue. You side on the side of life, even if it's potential. You side on the side of life, but inevitably that discussion runs down the road of what about pregnancies caused by rape, incestuous rape, and things like that, and then health issues with pregnancy and things like that. I guess maybe this is more of a philosophical than a legal question, but then where does the pro-life argument go, do you think?
So I'll tell you where I would argue it, right? I would say, one, if somebody has a religious objection for paying for an abortion that occurs as the result of rape, I think it's their right to have that religious objection. And I think the truth of the matter is if the government thinks that's a problem, the government can provide the abortions. Planned Parenthood. We don't have a shortage of people who are very much in favor of abortion for rape victims, right? That is a very popular position. And ultimately, if someone happens to have that view, I don't see anything wrong with the law protecting it. Sorry, you said the rape victims thing, and then you said health problems. The health problems argument also, to be honest, to be very honest, it's a fake. So there's this argument that, well, some people use birth control pills to treat cysts, right? And it's not fair to not give them the birth control pills to treat cysts. Well, the fact of the matter is, nobody has presented anybody who's got a religious objection to using birth control pills to treat cysts. I've never heard anybody have that objection. The schools that have been in question when people have talked about this have said, well, they don't have a religious objection to providing the pills to treat cysts. I'm sure they don't have an objection to using birth control pills to treat headaches. They have an objection to using the pills as birth control. So one, there's no objection to it. But two, if the government is so concerned about people with cysts, ask yourself this. Well, what else is in this law? What else do they require to be paid for free to treat cysts? Right? Because if people have a cyst and it bursts, you get antibiotics to treat your cyst with antibiotics. Sometimes you need surgery to deal with a cyst too. But guess what? The government doesn't mandate free paying for antibiotics because your cyst burst. They don't mandate free paying for the surgery. In fact, the only thing that they want to make anybody do for cysts is give out birth control pills. So if the goal was cysts, the idea of protecting contraceptives and only contraceptives is a bizarre way to do it. Again, I think, is it true that it's used sometimes for? It's absolutely true. I believe that 100%. It's absolutely true. But is there anybody who's got a religious objection to it? No, no one has a religious objection to it. So. I've had enough. How about you? I hear there's food outside. So thank you very much.